All right, and we are live. Welcome to Phil's First Party Parlay, where we talk all things timely and topical in the insurance restoration industry. I'm Phil Sanoff, trial lawyer with Morgan & Morgan's Insurance Recovery Group. At Morgan & Morgan, we have 55 of the best first-party lawyers you would ever want to know. We are in 25 offices in 13 states. If you've got any problem with any insurance claim, you need to come see us. You can reach us through our website, forthepeople.com. Hit pound LAW on any cell phone. None of those strike you fancy? Just call me direct on my cell phone, 713-825-3444. Morgan & Morgan's Insurance Recovery Group. Come see us. Joining me tonight is my friend Josh Autry from Morgan & Morgan's Insurance Recovery Group, Lexington, Kentucky office. Josh, come see us, my friend.
Hey, Phil, how are you doing?
Hey, man, good. Thanks for being here. And let me introduce you a little bit to the folks that are either with us tonight or are going to see this on the YouTube channel. We repurpose it on there. We repurpose it on a few podcast platforms. So for folks hearing this at some time, need to know about my friend Josh. Josh is a real live lawyer. Let me tell you about Josh. Josh has about 17 jury verdicts to his credit, has been involved in dozens of appeals, 30 to 40 appeals. Is one of the most intellectual and can have nuanced conversations. I'm glad that Josh is on my side when I'm trying to figure stuff out. I go to Josh. Josh was kind enough to take some time to visit with us this evening. Josh, again, thank you and welcome to the show.
Well, thanks, Phil. It's always a pleasure talking to you. And this issue we're talking about tonight is one that we are seeing all the time. And we're getting more and more calls by the minute, it seems.
By the minute. Before we jump into that, we're going to be talking all things business interruption tonight. Josh is so far ahead of the curve that Josh has already filed a lawsuit on behalf of some local breweries there in Lexington. Before we get to that, Josh, I'm always afraid that I'm going to leave off something that folks really need. The other folks that hear this, that are seeing this and hearing this, need to know about them. So please, I don't want to act like I got your introduction perfect. If there's something that folks really ought to know about Josh Autry, please help us there.
I think you basically covered the bases. The only thing I would add is for insurance work, I did do insurance defense at a prior law firm for 5 years. So I do have a little bit of experience on both sides of the ball, and I am very familiar with the claim handling process and can sort of sniff out where bad faith is and where it isn't, what claims should be paid, what claims shouldn't be paid, what claims that the adjusters are going to want to settle versus what claims they're going to want to fight. And I've been involved in all of those conversations on the insurance defense side of the ball.
And that actually reminds me, I forgot two things to introduce about you, two important points that I wanted to make sure folks know. Josh is not only licensed in Kentucky, Josh is also licensed in Pennsylvania, and like a lot of us, has handled cases all over the country. So anywhere you think you might need Josh, give us a holler. We'll make sure you know his contact information before we run out of here.
Of course.
The other thing about Josh is that he knows where the bodies are buried for insurance claim work. He was on that side for a while and got tired of what he saw and came to start helping the good guys. We're awfully glad he did. So Josh, tonight we are here to talk about business interruption claims all over the news, all over the country. Rightfully so, are all the business interruption claims. Now, as folks know that have heard the show, and as you and I talked about during our prep sessions, I'm a trial lawyer. I believe in the magic of three. I examine my witnesses about three things. I cross-examine witnesses about three things. I make arguments to judges and juries about three things. So I gave you plenty of notice to come up with 3 things that we were going to talk about tonight for business interruption.
Yes.
We'll have you back on another show. There's so many things to talk about. Tonight, we're focused in on business interruption. What are the 3 points for your sake to talk about tonight, including the lawsuit that you filed already?
Yeah, so the first thing is what to do as a policyholder. If you think you have a claim, we want to talk about what your options are and what steps you need to take to get the ball rolling on a claim. The second is the main type of denial we see of these coronavirus business interruption claims. And then third, what happens if there's a specific exclusion relating to viruses. So we'll talk what you do as a policyholder, how you file a claim, the main reason they've been denying these claims, and then also specific issues about virus coverage.
And throughout, part of the advantage for folks that are watching us now or hearing this later is to talk about what really happened. It's not just theory about these legal type of issues, what really happened in your case. So as we go, I want to make sure to emphasize for you, please bring up what really happened in the case you filed.
Of course.
Before we get going that way, we've got some attendees here. Let me make sure. I sometimes forget to do this. Any question, we'll stop along the way. If there's a question typed out into the chat, we'll make sure to cover that. I've got this opened now so that we get there. So let's talk about, to start off with, you want to talk about what should the policyholder do. In addition, let's talk about what your policyholder do that you filed suit for. So walk us through that. What should policyholders do from your perspective, and how did that play into the real life case that you've already filed?
Yeah, so my policyholder in this particular case is a brewery, or a brewing company, owns 3 tap rooms or restaurants that serve food and alcohol, both in Kentucky and Indiana. And they knew that they had purchased business interruption coverage, and they knew that included what we would call civil authority coverage, which you pay extra for to give you protection in the case that the government shuts down your business. And they filed a claim with the insurance carrier when they were shut down by the pandemic and the restaurant closure order for restaurants in Kentucky.
So we've all heard lots of folks that their agents or other folks within the insurance companies have told them not to file a claim.
Right.
Your folks went straight into filing a claim.
Correct. And this is something that we do see all the time, both in this context and in other contexts. People will call their agents about a claim, and the agent may opine over the phone that they don't think you have a claim. And they may say, oh, that's going to get denied. Don't file that. It's a waste of your time. Well, your agents typically are not lawyers, and they're typically not adjusters. They help you find coverage. They help you bring claims, but they don't make the decisions on whether there is a valid claim or not. And a lot of times on these close calls, your agent may have an opinion that's just incorrect. And it could be because they haven't researched the issue. It could be because of changes in the law. For whatever reason, they are very well meaning. But if you don't file a claim, you never know what the insurance company is actually going to say. And if you don't get the response from the insurance company, you can't bring that to a lawyer. You can't look at it yourself. You can't compare it to the policy to know whether the insurance company is correct or not.
So what are you telling folks? Anybody that comes to you, is it covered? Is it not covered? Should I file a claim? Should I not file a claim? I heard I shouldn't file a claim. What are you telling folks?
I believe in this circumstance, if your business is mostly shut down or completely shut down, and you have purchased business interruption coverage, you should file a claim.
Okay.
Practically speaking, these documents are often hundreds and hundreds of pages, involve additional coverages, followed by additional exclusions, followed by riders in the policy that the insurance company calls endorsements. or amendments to the policy, sometimes specific to certain states. And then you also run into the context that some jurisdictions are going to say that provisions or exclusions in the policy may or may not be invalid. So I think no matter what your policy says, don't just assume that you don't have coverage. You should bring the claim, the value of your claim right now. If your business is shut down, you should bring a claim, submit it, but practically speaking, they're going to deny it. But without bringing a claim in the first instance, you're not going to get that denial in order to have an attorney assess it.
So what happened with the client that you've got that you already filed the lawsuit for? What happened after they filed the claim? Now, did they come to you to file the claim, or did they come to you after they got denied?
They came to us after the denial. They promptly filed the claim in, I want to say, early to mid-March, when restaurants and alcohol-related businesses were shut down for in-person service in Kentucky. And I want to say about 10 to 14 days later, they got a denial from the insurance company, which in their case was Union Insurance Company or Union Group out of Iowa, Cedar Rapids. But practically speaking, the response, as we've seen, is exactly the same. These carriers are denying these claims no matter what the policy says.
So that was
an industry-wide position. Yes.
That was step one, that your folks went and filed the claim. They got denied. They came to you. What is your topic two? And so tell us in general about topic two and how that plays into what happened in your case that we filed for you, that you filed for your client.
Well, I'll say one more thing on topic one about what you should do as a policyholder. If the carrier says they need more information, if they, maybe they want more information on your profit or loss, about your potential damages, the extent of it, maybe they want to ask about whether there's been an outbreak on your property, whatever that information is, don't hold back, because the last thing you want is to have a good claim, but you lose out because they say you weren't cooperating.
Got to cooperate. Always got to give them. Right. Sure.
Even if it's a waste of time, even if they know it's a waste of time, it's a waste of time. You got to go through those hoops just to make sure that they can't say you didn't dot your I's or cross your T's. But
hopefully they will have come to someone like us within that time, and we can help them compile and help them put it in the format of what we know the insurance company wants. When they start asking those questions, that's certainly a time when policyholders should not go at it alone.
Right, exactly. So you would ask me about the second step or second topic, and I'll say that it's a pretty broad issue that we're running into here in every single one of these cases. All of these policies, and we've looked at, I feel like 100 policies just in the last maybe 14 days on this precise issue. And I mean, we look at policies all the time, but the language in these policies is you get coverage for physical loss or damage to the property unless excluded. Okay. So we call that an all risk policy. But what it essentially means is you get coverage for loss or damage unless there's an exclusion. And then you run into some additional coverages that may amend that or additional exclusions, and you get into that. There's another type of policy that's pretty uncommon, which we would call sort of like a peril policy, that gives you a line item of you get fire coverage, you get tornado coverage, you get hurricane coverage, things like that. But most policies that we see are what we would call an all risk policy. So they use this language, physical loss or damage to. Every single carrier that we have seen is taking the position that if your business is shut down, you have not had physical loss or damage to your property. And the issue that we are going to be litigating in all of these cases is that word loss. And the carrier's positions on this, or position on this, it's uniform, is that loss, because of the word physical, requires alteration of the property. So it requires, smoke damage to your wall in the case of a fire, or something along those lines. But one thing that we have going for us in these cases is there is a body of case law that's been developing around the country since, I want to say, the 1950s, that says that physical loss is different than physical damage. And the word damage generally requires some sort of physical alteration to the property, but the word loss doesn't. So loss can be loss of use. And in the context of a business being shut down, civil authority coverage, that's exactly what we're talking about.
And so all the policies we have, literally, you and I are on a Morgan & Morgan task force that has been reviewing all of these. You and I have literally looked at well over 100 policies in the last 3 weeks. And they all seem to be worded that same way, with some iteration of direct physical damage or loss, direct loss or physical damage. Why are policyholders seem to be so dismayed at the way that the carriers, what's been your experience with your clients, particularly the one that you filed for? What are they getting the response from their carriers on how they're parsing out those words, even though what's helping us is with the exclusions, it's the carrier's duty to prove every word. We're parsing out every punctuation. Is it a compound sentence? Is it two sentences? Talk a little bit about encouraging the policyholders on what their exclusions might say.
Yeah, so the carrier's position, if I'm understanding your question right, and obviously please stop me if I'm going down a rabbit hole that you weren't thinking, but the carrier's position in all of these cases, in the denial letters that I am seeing, is you haven't shown some sort of physical damage to your property, and on top of that, you haven't shown an outbreak at your location. So and the second portion there is in line with some mold case law that they have in mind. So, and that's sort of the remediation cases where the courts have generally ruled that if remediation is necessary, then that is loss or damage, and the carriers know that. So they're throwing in that you haven't shown the need to remediate the property on the back end, but they're starting out with this, you haven't shown that there was physical damage to the property.
And you've touched on it in the way that you're describing the exclusions about the loss and the loss of use. How is that going to vary? Let's talk so that the people that
Right.
this or hear it later about the idea of the direct loss and the imminent threat of loss, those types of things, and how that will play into folks being able to pursue their claim.
Right. So direct loss is you can't use the property right now. That's direct. It's not indirect. It's not a step removed. You currently are not unable to use the property. The issue of risk is also an interesting one, because one kind of policy that we see allows recovery for the risk of loss. And that's a little bit less common, but those policies are out there, and some major insurance companies write policy with that verbiage. And in those cases, I think our argument for coverage is going to be even stronger, because you've got the risk of contamination of an outbreak on any high traffic business. I mean, practically speaking, if you're a mall, if you're a theater, if you're a bar, I mean, and in some states more than others, but across the country, the U.S. has become sort of the epicenter for this pandemic internationally. And, I think it's easy for a lot of businesses to argue for a risk of an outbreak. And if that outbreak standard is what the carrier sets forth in these cases, it's going to come back to bite them in those risk of loss policies.
And the business owners are not insurance policy interpretation experts. They're calling their
Right.
insurance companies, their agents. They're being told they're not covered, not to file a claim. We've already been through that and advise you have the right to file a claim.
Right.
File your claim. You've talked about what type the typical denials we're seeing. What's the third point that we need to transition into for folks either here or seeing this, hearing this?
Yeah.
Later?
The third thing is there anything in your policy that uses the word virus or disease? Uses either of those terms. So some policies, and this is somewhat uncommon, but some policies have virus or disease coverage. And you may pay a monthly premium for virus or disease coverage. And your agent may have sold it to you. So I think we looked at the policy just the other day. It was a childcare company downtown Brooklyn, I believe. And they had purchased disease, virus, and outbreak coverage. And their carrier denied the claim under this same thing we've been talking about. And they said, well, you were shut down, so you never had an outbreak on your property. So even in New York City, where like, 1.5% of people have tested positive, the carrier's position is going to be, you should have let the outbreak, you should have let the pandemic happen on your property, then you would have had a claim, as opposed to, shutting down your property as you should in the middle of an epicenter or an outbreak.
You and I went through that policy last week, word for word, provision by provision. And even with that specific type of additional added in coverage, they get the blanket denial letter. You should have let the outbreak happen. We're not covering you. Unreal.
And other types of businesses that may have purchased that coverage. And honestly, when you're going through everything with your agent, you may have forgotten what coverages you purchased. But other types of businesses that kind of coverage is offered to is sometimes like gyms or medical businesses. Now, in some states, medical businesses have a little bit, some of them have been deemed non-essential. If you're on sort of the outskirts and you're elective. So in Kentucky, for example, chiropractors were basically shut down. I think they've reopened now, but I think they were closed for about a month. And businesses like that sometimes do purchase these additional coverages for virus or disease. And again, we are seeing these claims get denied, even though the policy holder has purchased this coverage for this very reason.
Josh, we've got a question in our chat over here. Friend of the firm, friend of the show, Ryan Davis has asked the question. What is the equation for damages? Is it what the business nets or grosses? I know we actually have a call with our expert, I think on a couple of experts on Thursday morning, I believe, to go through that equation more. Since you're the guest on the show, I'll let you address that. I'll defer to you.
Yeah, so most of the policies we look at, and there is quite a bit of variation.
There's a little variation
to policy on this precise issue. But the most common framing is net profit plus expenses. And so, if you're running a loss, you're not going to really get into that net profit very well, but your expenses are going to be quite hefty. And I think that's the issue that a lot of businesses are running into, where those operating expenses that they're continuing to pay.
Those continuing operating expenses that are just like fixed expenses, what most policies provide for are those ongoing net expenses and the net profit, and different, as you say, different policies define it different way. As we always say, you got to read the policy, but most of them are going to say this ongoing expense plus net profit, and that's essentially what we're going to get into when that comes.
Right, and that's the most common definition we see, but there are other definitions as to whether it's net or gross profit, but it's typically profit plus expenses.
Now, I want to give us a chance. We've got 5 minutes left. I want to give a chance for you to talk more about the lawsuit that you filed. What type of policy? How strongly do you feel? What are the type of damages that for your client, for the lawsuit you
Yeah.
filed that you're looking at?
So the brewery that we work with, they have, I want to say, hundreds of other restaurants that they distribute to. All of those restaurants were shut down. All of those bars were shut down. So their entire business model was essentially closed. Now, practically speaking, in Kentucky, they were still allowed to do takeout, but that's minuscule in comparison to their normal operations. So their net profit losses and their expenses are going to be quite hefty, and they have a substantial policy for that very reason, and they pay a substantial premium for that policy,
Sure.
and
For the right
obviously,
to have that coverage, there's
exactly.
money, right.
But that premium doesn't mean a whole lot when you have a big claim,
Right.
because that's the number that the carrier is looking at. And in a lot of these cases, the carriers are going to fight this pretty hard because they know that they're getting a lot of claims on this very precise issue, because so many businesses were shut down at the same time, essentially across the country. And the carriers know that if they pay one, they're paying them all for the most part.
That brings up a good point I wanted to make sure we covered, Josh. Lots of people are going to see this repurposed on different video channels. People are going to hear this on different podcast platforms. Are there any businesses that you think should not file a claim if they've got a loss, or are you willing to take a look at whatever anybody's got that they've lost money, they need to file their claim and let you evaluate it? How would you let folks know?
We are looking at absolutely everything. I mean, the only exception I would say is if your business is better. So, I mean,
if you don't have a business income loss,
right,
you can't recover a business income claim.
Yeah.
Right.
Uber Eats is probably doing fantastic. Grubhub is probably doing fantastic. So there's plenty of industries or subsets that are internet based or delivery based that are actually doing better. So, Domino's probably doesn't get a whole lot of in-store traffic, so they may be doing substantially better. But I would say probably 80% of businesses were negatively affected by the stay-at-home orders, the pandemic itself, and also the essential business orders in various states.
I can tell you the Uber Eats folks in Roscoe Village neighborhood of Chicago, Illinois are doing quite well. I know this from the credit card bills that happened to make it to me from that point. My lovely daughter, love you, baby. Keep ordering Uber Eats. Yeah, there are some businesses that unfortunately, it's just the way the world works, that are going to be okay through this. But the vast majority need to get the help that they deserve, ought to get the help that they deserve. Well, Josh, we're right up next to it. If you have anything that you need to say to make sure folks understand before I take us out of here, it looked like you were about to talk. I didn't want to cut you off. I just want to make sure we need to close it through.
Of course. I will say, just the last thing, if your carrier says that you have a specific exclusion for viruses or disease, you should still file the claim.
Great.
We are looking at every possible avenue. Some of these exclusions can be narrowly construed to only apply to property damage claims. And again, here we're talking about property loss. Some of these cases, the exclusions are not, as it appears we're seeing, are not actually sent to the policyholder. And so in those circumstances, the exclusion won't be valid under the law of most states. In some states, the exclusions weren't approved properly by the regulatory agency in those states. So even if your agent says you have a virus exclusion, your claim is big enough in this case that it's worth digging in there. So file the claim, let them deny it, and then let an attorney take a look.
Josh, for folks that see this or hear this and say, I don't want to talk to Phil Sandoff, I want to talk to that guy, Josh.
Yeah.
How do I let them know to get in touch with you, buddy?
Of course. So I can just give my cell phone number. It's 717-254-0774. It's a central Pennsylvania area code, but I am located now in Kentucky. I used to be in Pennsylvania, where I practiced there for 11 years before coming to Kentucky.
That's our friend Josh Autry. I'm going to take us home. Josh Autry, Morgan & Morgan Insurance Recovery Group, Lexington, Kentucky. As we say, Josh, thank you. We're going to have you back. There's so many other things to go through with you. As I always say, thank you to the folks that are either here this evening, see this on the various audio channels, hear it on the various audio channels, see it on the various video channels. Morgan & Morgan Insurance Recovery Group, come see us. We're going home.
Thanks so much, Bill. Take care.